Ladies and gentlemen, good morning. Welcome to our sixth and final webinar. My name is Len Bunton. I've been involved in all the webinars to date. Just one thing to mention before we kick off, there is a facility for questions and hopefully we'll get a few and hopefully you'll even get some answers. So please use that facility. It's good to get engagement from our audience. If this is the first time that you've joined us, all of our webinars are on the CICB forum website. And our Ian Mason, who's our Director in charge of communications, has said that these are getting quite big hits from people. So please go into these and share these with your colleagues because there's a lot of very, very good stuff on there. As far as the future is concerned, what we will be doing, we'll be reacting to the requirements of the various member organisations in the forum. If they see a particular requirement for their members, then we will produce future webinars on these subjects. We're looking possibly at one on mediation in 2021 and maybe a question and answer session with our distinguished presenters. If you have any topics that you think might be of interest, then please let us know. You can contact us through the forum website. Now, sadly today we don't have Rudy Klein with us. Rudy has something has come up that is not available, but I'll introduce our presenters. In the middle there is Ian Honeyman, the Commercial Director of Scottish Building Employers Federation, and Angus Pearson, who runs his own consultancy and is heavily involved in advising contractors, subcontractors and employers, and has now started his own career as an adjudicator for reasons better known to himself. I'm sure he'll be a powerful addition to the team of adjudicators in Scotland. Thanks also to Ian Mason and the communications team that have put these presentations together. They've put a tremendous amount of hard work into it and are to be commended for the quality of the presentations that we've had. One further thing, we are in the process of putting together a presentation that will go on the website very shortly. And what we've done is go back through the last 5 webinars and pull together what are our recommendations to help you run and manage construction projects more efficiently. So there's a lot of good messages in there. These should be shared with you and your colleagues, and we're hoping that if a lot of these recommendations are implemented, then the industry should find it more favourable in terms of getting payment timely and in the amounts that you're claiming. So these are all very valuable lessons for you to take on board. We've mentioned the forum before, it's still going strong. One of our current activities is in relation to producing a paper for the Scottish Government on the implications of Brexit, which is a huge area of unknown territory for us all, and that should be available fairly shortly. We've added 2 new organisations, the Civil Engineering Surveyors and the Glass and Glazing Federation have now joined the forum as well. So let's kick off with the presentation, but before we do that, I thought it might be quite useful to ask our 2 presenters, how are they seeing the marketplace at the present moment, and what are the issues that are emerging in terms of payment, cash flow, and in particular, implications of COVID clauses. So, Ian, could I ask you maybe just to take a few moments to give us your views of your members on these subjects?
Yeah, thanks, Len. Obviously, at the beginning of the whole process, everything was unknown, and to a certain extent, we were all sort of finding our feet. But the initial sort of arrangements that were being put in place were all about communication, collaboration, trying to work together to get to the end of this. And there was 2 distinct areas with the public works and private sector works. Generally speaking, the ethos of the thing was all about trying to get a fair and reasonable way of getting us through this thing, but nobody really knew how long this was going to last. When we came out of it the other end, generally up until the point of restarting, probably in June, July time, the agreement was going to be that we were getting time, but no money. Public sector was slightly different to that. Some money was being paid, particularly in relation to getting the work restarted with any new measures getting put in place. But the sort of impact of post restart is still not really fully hit, although it's becoming more evident that the time is being granted for some of the delays, particularly in relation to the original lockdown period. But some of the full delays haven't really manifested themselves in its entirety, because some jobs that were coming to the end have obviously been dealt with reasonably quickly, but it's jobs that were sort of almost just starting, the full implications are still not there because they're not till the end of the projects yet. But the costs that have been incurred due to restricted public activities on site aren't necessarily getting met. The public sector is probably listening, and there's probably opportunity to still finalise these things. Private sector tends to have basically said, we'll give you time, but we're not going to be getting any money. And obviously that's an area where it may be fine on a job that only had a short period to run, but some of the longer term durations after that, it's still a worry. And obviously some of the costs that have been incurred are still sort of ongoing. There's issues in relation to it that have been quite surprising, in that some of the productivity issues that we thought might be a problem haven't been there, albeit that the duration of the job has been extended. But we're actually finding that the productivity on projects has actually improved in some areas. But as I say, the end of the process isn't there yet, and there's still issues that are lagging. And I think it'll be a wee while before we actually get to the conclusion on that.
Okay, thank you, Ian. Gus, I know that your inbox is bursting with people that have got cash and payment problems. So how are you seeing things?
Yeah, certainly seen an uptick in the number of payment disputes that have gone to adjudication. Our office has been busy all the way through from May, constantly in adjudication in one form or another. Usual sort of pile up of payments that maybe haven't been dealt with during lockdown and things like that. We're still seeing disputes over payments going back to February, March. So, those that haven't really taken the time to clear up all the old payment issues have now sort of patience has run out. People are desperate for the money, so little choice. Another couple of issues really that are starting to appear. We've had a couple that relate to wrongful terminations around COVID issues, where people haven't been able to return to work or working under restrictions. It's been used as an excuse that they've been failing to proceed regularly and diligently. So there's a little bit of fallout there. And really the other area that we've noticed a tangible difference in vibe is around insolvencies. So as anybody involved in adjudication is probably aware, there's been a few cases recently relating to insolvent parties adjudicating. So a lot of liquidators and insolvency practitioners are using the process as a means of trying to draw matters to an end where contractors or subcontractors are insolvent. It does have its own issues, but I think into next year we may well see even more on the insolvency side the way things are going.
Okay, thank you. So let's look at the 7 different areas this morning that we're going to be talking about. First of all, I want to emphasize something that all of us have endorsed in the first 5 seminars, and that is the importance of keeping records. Records. If you've got fully substantiated records of the history of the project, that will take you a long way to a successful negotiation of amounts that are due to you. And there's an old expression, fail to prepare, then prepare to fail. If you don't prepare properly and you present an adjudication submission to somebody like myself, it will fail. It's as simple as that. Most adjudication situations where you get a bad result is because the claim has not been substantiated. So that's a big thing that the industry has got to do to make sure that they're putting their cases together. So what I'm going to do is give my own personal view on some of these issues and ask my colleagues to chip in. And the first thing is negotiation. And really a plea to the industry to keep talking. Use this vehicle, virtual meetings, to face-to-face discussions about your valuation, your application, and why it's not getting paid. And let's get rid of the email bandits that bang out stuff to each other and they don't actually are not prepared to talk to each other. So as best as you can, keep negotiating with the other people that you're dealing with. Try and narrow the issues down between you so that it may well fall down just to one particular issue that needs a resolution, and we can talk about how you can take that forward. So negotiation is the best way forward. Ian and Gus, do you want to comment on anything I've said there?
Len, I would say that's the main issue, because whatever it is at the very beginning, when you started coming across problems, having an early discussion, trying to resolve them at that point in time is certainly the best way forward. Because if you don't, only things are going to escalate, and then it gets to a point where you could end up being so far down the line it becomes more difficult to resolve it. But it's easier to have that conversation and try and get, as you say, crystallize what the potential issues are, and then focus on that rather than you have a bigger problem that's just becomes almost too big to sort of do it in a short term. You almost need to get someone else involved because you can't see the wood for the trees. But I think negotiations is probably the most important thing at the beginning.
Gus, want to say anything?
Yeah, people need to keep talking. 8 o'clock this morning, I had an email in response to a payment notice produced by an erstwhile QS to a subcontractor, and the subcontractor has frankly gone off and into a lengthy diatribe. Instead of picking up the phone and trying to agree and improve position, it's all too easy just to knee-jerk into doing something you might regret later. Pick up the phone and talk to people. So it's old-fashioned, but it works.
Yeah, okay, thank you. Now, just bear this in mind, ladies and gentlemen, it takes two to tango. So if the other side or one of the parties is not willing to engage in discussion, what mechanisms are open to you? Now, the first one on the screen there is mediation. And surprisingly, certainly in my own experience, mediation hasn't featured greatly in the Scottish construction industry. But it's an excellent process where you bring in a third-party facilitator to encourage engagement between the parties and kind of steer them to get towards a resolution. And I think the most critical thing about mediation is that the parties are in control of the process. If you go to adjudication, then you're often not in control of the process because you've appointed solicitors or claims consultant to handle things for you. So you need to get the decision makers in the room who can listen to what the other side are saying, explain why they're not going to make a payment, put your own point of view across, and hopefully at the end of the day, you can come up with a satisfactory solution, shake hands, walk out the door, and continue working together. And one of the things we'll be doing in the forum is promoting the use of mediation in the construction industry. That's an initiative that we're taking on. Ian or Gus, do you want to add any comments on mediation?
I'll weigh in there, Len. I've been involved in quite a few mediations. The thing I like about mediation is that you can go places that you can't otherwise do within an adjudication, or worse still, in a litigation. So a good mediator will help facilitate the right discussions, but come up with solutions that might be outside the contract or might play on relationships and try and use those angles that, whereas a court or an adjudicator has to look at something in black and white. So it is a flexible process, and as parties to the mediation, you've got quite a bit of control over what you can throw into the mix. So that's what I would just like to add there.
Okay. Ian, do you want to add anything?
Yeah, but the only thing is pretty much what Gus is saying. The only thing is it's obviously something that can be ongoing. It's not, you don't have to wait till the disputes in a position of heading down to the courts or such. Like, it can be ongoing, and it's obviously something that effectively it puts a referee in between the parties that can help the situation, rather than it getting into in the corner and you don't see the other person's point of view at all. So I think it's a positive step. I think it depends on the particular nature of the dispute. It has to be reasonable, you know.
Okay. Now, expert determination, I must say this is a process I favour greatly. I think it's a tremendous process because what you can do if you're in a deadlock with the other side is suggest you go to expert determination. And by that, I mean you would bring in an experienced industry person. It could be a quantity surveyor or an architect, engineer, or an experienced dispute resolver. And what you do is you allow that individual to read the submissions, to talk to the parties, and to come up with a binding determination of who is due what, or whatever the issue is. And the great attraction to me about expert determination is you're not fettered by some of the nonsense that adjudicators have to face up to of jurisdictional challenges, all sorts of stuff, timetabling issues, natural justice. You're clear of all of that. You're bringing in an industry grizzly bear to get their sleeves rolled up and get piled into what the problem is and come up with his own view on it. So I think it's a great process, and it's one that we should be using more and more often. And I think it's particularly good for payment, final account issues, and extension of time issues. And the great thing about it is you can get a determination up and running very, very quickly, because by the time the parties have reached an impasse, all the documentation is there. So it's a case of bundling that off to the third party and let him do what he wants to do. Give him or her free rein to deal with the dispute. So that's a process I would definitely be encouraging, particularly as it's should be a short time scale. Again, I'm going to ask my colleagues. Gus, any comments?
Yeah, similar experience, Len. Any time I've been engaged in expert determination, it has been fairly quick. Anybody that is considering adopting it as a process, just make sure at the start of it that you give the determiner the authority to reach a binding decision, so that whatever they come up with as the answer to your dispute, that it has an effect. I have seen circumstances where it's all been left a bit loose in terms of the appointment, but again, a good expert determiner will settle that out for you at the outset. But quick, cost effective, and draws a line under things. So yeah, good process.
Okay. Ian, do you think that'd be attractive to your members?
Yeah, in certain circumstances, I think this kind of area is probably best suited where there's a technical or a specific nature to the actual dispute, and it's probably where it's isolated. If you get into a situation where the dispute could have consequences on further things down the line, it can potentially not necessarily be the ideal way to go. But specifically for a decision on a specific matter that's technical, you're bringing in someone who's got that expertise and knowledge, and I think it does work quite well, I have to say.
Yeah. Okay. Right, let's tackle the big issue then, adjudication, and what do we all think about the adjudication process? It's quite incredible. It's introduced into the industry in 1998, although in actual fact, in practice, had been used previously in my experience. The RICS is currently appointing about 120 adjudicators a month. And when you add on the other nominating bodies, you're maybe talking about 160, 170 references to adjudication every month. Although obviously a lot of these settle relatively quickly when the shot is fired, so to speak. What are my views on it? Well, it's a high-risk strategy, I think, at the present moment, because the key thing about adjudication, the key reason it was introduced was to make sure that it benefited cash flow in the industry. But the big threat at the present moment is that even if you get a decision in your favor, you will not necessarily be paid, because a respondent who's having to pay out a significant amount of money will have laid the grounds for jurisdictional challenges, breaches of natural justice allegations, and these will all be brought into play when the referring party or the winning party goes to court to get the decision enforced. So it could be 6, 7, 8 months before you actually arrive in front of a judge to get a decision as to whether or not your decision should be enforced. So you have to ask yourself, what is the point in having a process like this that doesn't expedite payment? And how do we overcome some of these jurisdictional and other issues? Well, the answer is, I don't think you ever will. Because on one side, you've got somebody that wants to be paid, and on the other side, you've got somebody that doesn't want to pay out any money. So that's the tension that you've got. So to my mind, this is the big issue over adjudication moving forward, the uncertainty that you will not be paid. So I want to go back to what I said at the start of this, getting your submissions correct, getting your records there. These are all key issues in putting in front of an adjudicator a sustainable case. So you're presenting your best evidence to get a winning result. As far as jurisdictional challenges are concerned, my issue about all of that, and I see this in almost every adjudication, I fail to understand sometimes why the referring party doesn't simply say, I'm going to withdraw the challenge, I'm going to withdraw the adjudication and start all over again, so that you've removed a jurisdictional challenge. Quite often they plough on. It's entirely up to them. I don't express any views on it. I don't understand it, but it's entirely up to them. And it seems to me to be more sensible, if a challenge arises, then get it off the table. If somebody says the dispute's not crystallised, then crystallise it. If somebody says you've referred more than one dispute to adjudication, then stop and start again. It's inconvenient, but it's a damn sight better than 9 months down the line not getting your payment. Simple as that. Anyway, I'm going to ask my good friend who's dealt with more adjudications as a party rep than anybody I know. Gus, what is your current view on the adjudication process?
I think overall, then, it's a fairly positive thing for the industry. I think if we go back to why it was introduced in the first place, arbitration and litigation were long and expensive processes. We often hear of it referred to as rough justice, being that it's 28 or 42 days, often to decide quite complex issues. But in my experience, the vast majority of cases, most adjudicators will control the process and come out with a decision that's right or nearly right, given the constraints on them within that time scale. It's not quite the Wild West that it once was. And I would always encourage parties to keep the notices of adjudication and the referrals and all the submissions as brief, clear, and as punchy as possible. The purpose is to persuade an adjudicator in the merit in your case. Keep it to that. Keep the emotions out of it. Party reps often get wrapped up in emotional language and things like that. Just focus on the issues. And sometimes, rather than rolling up a complex adjudication with many issues, break it down into bite-sized chunks. Consider going for early declarations as to principles. And then that maybe gives you another round of negotiations before you may have to take it into a second round. But overall, I think the process has been a benefit to the industry. I share Len's concerns that there's a lot of technical arguments out there come out in relation to jurisdiction. A lot of them a bit pie in the sky, simply as a means of trying to avoid and defer payment. But Len's absolutely right. If you can get them off the table with jurisdictional challenges early, then you should consider that. That's what I would like to add. I don't know if Ian would like to weigh in here.
Well, I see the adjudication sort of process from a slightly different perspective, because SPF are a nominating body, albeit we don't get involved or have many applications for the sort of nomination of an adjudicator have gone down since the original start back in 2000 and whatever, I think we were involved in it. And but it's interesting to see that there's a set procedure that everybody needs to follow, and sometimes they can fall at the first hurdle because they don't follow the sort of guidelines of issuing the original notice at the same time to all parties and to the, including to the nominating body. And sometimes I find that I get an appointment or a request for a nomination of an adjudicator, and I've only got like a couple of days left within the 7 that's there to get somebody on board, which can be proved difficult. And it's also about one of the things that's on their timing as well. Sometimes adjudications are coming in at a particular time in the lead up to certain holiday periods and such like. It's not ideal, all done for particular different reasons. But at the end of the day, all that can end up happening in a situation like that is you don't get an adjudicator nominated, and as such, you end up having to start the process again anyway. So it's kind of sometimes defeats the purpose. But as I say, the number of adjudications that have have been going up and down, and I think there's certainly in the next few while, I think we're in an upward trajectory looking at some of the statistics that are coming through.
Okay. Okay, thank you. Now, the exciting thing that's happened recently has been the introduction by professional bodies of low-cost adjudication schemes. The RICS, CIC, and TEXA have introduced a low-value adjudication scheme. The benefit of it is that there's a fixed fee for the adjudicator in relation to the value of the dispute. So, for example, up to £50,000, the adjudicator's fee is £6,000. Now, that's a good thing from the perspective of the parties because they know what their exposure is. Instead of that, they go into the thing open-ended and they really don't know what their costs are going to be. So I think that's been a positive move. There's also the summary procedure, which was brought out in the beginning of July. The RICS thought they should respond to the marketplace, and they introduced a summary procedure, which means that the adjudicator has to make his decision within 14 days, and that attracts a maximum fee of £1,000. So that's been a good initiative by the RICS to respond to the marketplace. I've dealt with a couple of them, and the parties have cooperated greatly. In some instances, one of them said, "I don't want the summary scheme. I want the full-blown scheme because I want to be able to present my case. I want to see the 4 rounds of submissions. I want witnesses, all of that sort of stuff." So it's really as a case of horses or courses, and I'm glad to say that the forum has promoted these processes. And again, if you're a contractor or subby listening to this discussion, you can go into the forum website and you'll see that Ian has put both of these schemes up. Now, I know that my good friend, Mr. Pearson, is not a great advocate of these schemes. Gus, do you want to highlight what your thoughts are?
Well, it's an early stage nervousness that I have. If adjudication is rough justice, you're going to get rougher justice for £1,000, frankly. That's my fear. I see that it comes from a good place, but I think there's going to be all sorts of jurisdictional challenges, particularly where parties haven't agreed on a low value scheme as part of the rules of adjudication within the contract. So if you're a contractor or a subcontractor and you're writing conditions, consider putting in mention under the adjudication clause that if it's a dispute under £50,000, that you intend to utilise one of these low value processes. It works for both sides if you do that. It avails it to you without unnecessary jurisdictional issues. Skeptical is maybe not the word, but I'd like to see how it goes over the next year or so, and what results we're getting from it. That's my sort of concerns at the moment.
Would you accept the point that if somebody was under severe financial pressure and needed to get some cash in very quickly, in many instances to save their business, that would be an appropriate route to go down?
It depends case to case, Len. I think that if you have got those jurisdictional issues that we spoke about by imposing or trying to get a set of rules brought into play that might not exist within the contract, you might find yourself no further forward. By all means, if you can get agreement between the parties that you are going to follow these rules, have at it. I think it can only do a bit of good. There's some single point issues that can often resolve a dispute that can be dealt with very effectively.
So you could use the process to unlock a key factor in the dispute. Yeah. Okay.
Very useful for something like a declaration as to whether you're entitled to time or whether something is a variation, principles rather than the nuts and bolts, mechanics, pound notes, critical paths, and all the rest of it that I'd be loath to let someone loose on for a very nominal sum of money.
Right. Okay. Ian, your members, I would imagine they're attracted to this because of the cost certainty.
Yeah, I think so. I mean, obviously the sort of comparison in terms of the scheme, these schemes are obviously geared for slightly larger disputes and such. Like we had a similar thing through the homeowner contract that's out there in the marketplace, which is used for the domestic market, and obviously that enables access to the adjudication process under that use of that contract. And the scheme within that particular document is restricted to a fee. It was something like 10 hours. I think when it was set up, it was 10 hours at £100 an hour. Now, clearly, that's not a large fee in respect of a dispute. But it was, I think, the naivety on that was that small home extensions and such like shouldn't or wouldn't create complex problems. My experience is they can be the most complex problems as you could ever imagine and such like, and sometimes it can be more difficult to get. It's amazing how many adjudicators are very busy when a homeowner contract comes up. So it's there are horses for courses in that, but I think anything that brings a degree of certainty to the cost and you feel that you're going to get a result, whether it's good for you or bad for you, the result's done and it's done at a cost that's manageable. I think that's a positive thing.
Thank you. Now, another option is litigation. You'll see up on the screen there, the simple procedure in the Sheriff Court. It was introduced in November 2016. It's quick, inexpensive, informal. It can be used, for example, for securing the release of retention. You can fill up the paperwork yourself. You don't necessarily need legal representative. I'm not quite sure what the current position is regarding the Sheriff Courts in terms of the experience which they deal with issues. I understand that there are certain delays, so it would be worth establishing that before you went any further. And then, of course, claims over 5,000 can be commenced by a writ in the Sheriff Court using the ordinary cause procedure, and you would require a legal representation of some sort. So that is an option that you can go. There's also the potential to use arbitration. The Arbitration Scotland Act was introduced in 2010. There's been an awful lot of noise about the resurrection of arbitration in Scotland. In my own experience, I've not been made aware of any construction arbitrations. Again, you need somebody in the saddle that's going to drive the thing forward. Historically, arbitrations used to take 9 to 12 months, and we can't live with that process in the industry. But the Act has aimed at making it more cost effective, and there's also a new short form procedure which the CIRP has introduced, which I think is very effective. The process is confidential to the parties. Sometimes people don't want news to get into the courts and in the public domain. And there's a potential to have high costs because sometimes the parties have got counsel and senior solicitors or a team of solicitors involved. So in terms of popularity, it's not something I would personally would be recommending unless it really was a very, very major and complex issue. So let's move on to what everybody knows that I think this is an absolute game changer for dispute resolution. It's the conflict avoidance process, simply known as CAP. The background is that this was trialled by Transport for London and the RICS, I think about 2.5 years ago. TfL, as I understand it, were very concerned about the amount of money that were paying out in contractual claims and legal fees. So they approached the RICS and they jointly developed this process. And they brought their tier 1 contractors into the room and said, this is what we are going to do. And of course, they more or less are compelled to go along with it. And it means that a third party gets introduced in the earliest stages of a contentious issue arising. So it's an early intervention process. It cuts things off at the pass, range from a whole load of things, legal issues, design issues, financial issues, engineering issues, you name it. The third party comes in and engages with the parties, identifies the problem, and finds a solution that the parties can live with. The CAP will provide a written recommendation to an agreed timetable. And if one party doesn't agree with the recommendations, then they have the opportunity to say why they disagree. And that could well be remitted back to the employer or the contractor to consider the matter and have another go. But what TfL are saying, the proof is in the pudding. It's been hugely successful. And there's now a major attempt to roll this CAP process out right across the private and public sector in the United Kingdom. And what's been happening, the forum has endorsed the use of CAP. Ian's organisation has signed up to it, the Scottish Futures Trust. They have also signed up to using this process in their contracts. We're aware that NHS are likely to use the CAP process in the future. And many of you will be aware that in the early stages of the lockdown, the Scottish Government recommended that this type of process was necessary to ensure that people were treated fairly and that disputes were resolved as early as possible. So there is no doubt in my mind that this is an absolutely fundamental requirement of our industry to cut out the hemorrhaging of hundreds of millions of pounds that disappears every year on dealing with construction disputes. If you want to get involved, go into the RICS Conflict Avoidance Pledge, and you can sign up to that. They are now developing a process where there'll be different sort of degrees of membership, looking at the top end to somebody that says we're absolutely committed to this process and we will have it in every one of our contracts, down to individual members who want to promote conflict avoidance. Once you sign up to the pledge, the RICS will get in touch with you. We'll provide you with reading material. We'll provide you with template contract amendments and provide you with guidance notes. So my colleagues know my huge enthusiasm for this. I've bored them to death with it for the last 12 months. But Ian, SBF signed up, which was a great gesture, and I'm delighted that that happened. What are your thoughts on this?
Yeah, I mean, I don't think there's any doubt that a process like this is something that's new. I think the issues obviously that's been used down in the say transport for London and whatever was obviously a massive infrastructure project, and clearly something of this nature, the way it was set up here is for large projects. But I know the intention is to try and bring this down the scale so that it's not just available or open to massive infrastructure projects and such, like it's there and accessible to various levels of the construction industry, because clearly anything that effectively avoids, encourages discussion and collaboration and basically taking a view, looking at each other's points of view and bringing relevant expertise and assistance to that process has to be welcome, because clearly what we've got at the moment isn't necessarily doing what was originally intended to do. And this is a new process. It is new. And it'll take a while before it gets itself bedded in. But I think once it's established, I do believe it's going to be a positive step from dealing with a lot of the way that disputes are dealt with in the construction industry.
I think one of the feedbacks I've had is it encourages some innovative thinking.
Yeah, I think you're right, Len, it does.
It encourages you to sit around the table and say, okay, folks, how are we going to get out of this? Let's all put our brains together and find a solution that won't be perfect, but it will suit everybody, and we can get on with the critical thing here of getting this project built on time, on quality, and on cost, because that is the key to the industry. I think you share my enthusiasm for this.
Yes, definitely. I'd like to see it, bed in, be rolled out further afield. Anything that helps or contributes to avoiding further disputes from escalating at an early stage can only benefit the industry. We spend far too much on disputes and legal fees and all the rest of it, whereas I think that would be better spent within the sector itself and improving and driving things forward. I would like to see CAP be more accessible to the lower tiers of the supply chain. And that's something that I think we'll all have to work towards developing as it becomes more commonplace in the industry. So, but anything like this, it's a positive process, and I welcome it, and I look forward to seeing it proliferate.
I just to knock this one on the head about it's only designed for major projects, it's not. I mean, if you were an electrician in Kirriemuir and somebody owed you 25,000 quid, and somebody said, look, there's a very quick process here that we can bring somebody in to get this resolved, it's a no-brainer. You would want to do that. So you're right. We need to make sure this gravitates right down through the supply chain, because at the end of the day, these are the people that do all the work in the industry.
Len, one of the other things about this is the approach that this takes is more of a collaborative thing, and it puts the project at the sort of head of this, because at the end of the day, the project's got to get delivered, and it's in everybody's interest to deliver that project on time and if possible on budget. This effectively focuses the minds of all the parties to delivering that, rather than on one side fighting another side. It's basically trying to come up with a way that deals with the project as opposed to individual needs and wants. But it addresses these issues around the table rather than in the courtroom, if you like.
Yeah, I totally agree with that. I mean, one of the things I've seen as an adjudicator that I have seen, if you have an adjudication during the currency of a contract, I've seen the relationships between the team, the employer and the contractor disintegrate, and they never recover from that, and the project suffers. There's no doubt about it. So this is a great way forward for the industry, and it keeps the focus on doing what we're all here to do in the industry and get jobs built. So that's the end of the session. I don't know if Ian Mason can tell us if there's any questions coming in.
Not received any questions so far, Len. If anybody does have any, if they want to add them to the Q&A panel now, I think we have a couple anyway, Len, don't you?
Well, yeah, I did, and in my discussion there, I've actually covered the point that was raised. But anyway, we're come to the end of this. We've done it in just under 3/4 of an hour. I hope you found that. Oh, there is a question here. Can I just pop into that? Can you see that, Ian? There's a Q1.
I can, Len, yeah. George Finley has asked, is there a time limit to start an adjudication?
Angus?
No, is the quick and nasty answer. The wording of the statute is you can refer a dispute, meaning any difference at any time. So that's how I would look at that. Obviously, there's a time limit which is prescribed at law under the Prescription and Limitation Act and such like. So I think if you're within 5 or 6 years of your dispute arising, you should be okay. So you may decide to refer the dispute to an adjudication when the contract's finished, but anytime from the point of crystallization until it's prescribed at law, then you're free to refer it at any time.
Yeah. I think also, just to respond on that, one of the things we have seen recently is final account disputes that are going back 2 or 3 years, where the account's just been sitting unresolved, and people have said, look, there's maybe some cash lying about in here, and they've gone to adjudication on that. So the important thing to bear in mind about adjudication is you must make sure you've crystallized the dispute. You must make sure you've identified to the other side what the dispute is all about. So you've got to take some advice on making sure that happens.
Excellent.
Ian?
We do have another question from Shams Arif. Can we reject the decision from adjudication and appeal again?
Yes.
Short answer, probably not. There's no such thing as an appeal process in adjudication. The expression is that it's temporarily binding, and an adjudicator's decision can only be overturned either by agreement or by escalating it to court proceedings, or sometimes perhaps arbitration. So that would be my view on that. You certainly can't appeal, and you can't rerun the same dispute in adjudication. So once it's been decided by one adjudicator, that's it, provided you have an enforceable decision in place.
Yeah. Just to pick up Gus's point there, and I emailed him about this last night. I read an interesting extract from a case in the technology court, and it was in a situation where in adjudication number 7, the actor wanted paid for a variation, and the adjudicator said, I'm putting a nil value in this because you've not provided sufficient information. They then ran the same argument in adjudication number 8. The contractor had another go, and the judge said, this is an entirely different matter. The circumstances are different. So yes, the adjudicator was perfectly entitled to look at the proper valuation, because by that time the contractor had got his act together and had substantiated it. So that's an interesting little spin. But Gus is right. You might see in a defence and an enforcement action, for example, that one party said the adjudicator's reasons were unintelligible, and the court might take a view that they wouldn't enforce the decision. Okay, Ian, we've now got some more, I think.
Yeah, I've got another one. Someone's asked, how do you ensure a claim for an EOT doesn't lead into a dispute? And if it does, how should the contractor proceed further, particularly to recover costs from delays faced due to statutory undertaker diversions?
Sorry, could you read the question again?
Sure. First part is, how do you ensure a claim for an EOT doesn't lead into a dispute? And the second part was, if it does, how should the contractor proceed further, particularly to recover costs from delays faced due to statutory undertaker diversions?
Well, two things. You would make an application for an extension of time, and under SBCC 2016, the architect has got a 12-week period in which to review the claim and decide whether or not an extension of time is valid, giving you what relevance is relative. And that can happen during the contract, and after practical completion, the architect carries out a complete review of the whole situation, even in situations where the contractor has not claimed a particular relevant event. So if you get to a point that you're not being awarded the extension of time that you think you're entitled to, you would be at the point of having a dispute, and you could refer that to adjudication. Now, in terms of costs, not every relevant event, I think there's 18 of them, attracts money, a relevant matter. I think there are 5 relevant matters. So you need to be very careful about which one you're actually running, to run an event that makes sure it could be run as a relevant matter. I think as far as statutory undertakers are concerned, I don't know the contracts in my other office. I'm pretty sure you don't get money in relation to statutory undertakers, but you need to look at the conditions. Gus, you want to add to anything I've said, assuming you agree with me?
Yeah, as always, Len. There's no guarantees that you can avoid a dispute over time, but the starting point has to be making sure that your claim is properly founded. So correct notices, records, substantiation, and paint the picture. Present your claim in such a fashion that it's easy for the other side to evaluate. That's what you're trying to do, and it makes it more difficult for them to say no to the time that you're asking for. So I think that's your starting point. It may well be that a dispute's inevitable where you're at polar opposites, but I think you can probably refer to one of our earlier webinars where we were talking about notices, claims, records, and things like that. That's the most important part of this, because if that's going to form part of an application, you need to be confident that you can persuade an adjudicator that you followed the correct contractual process and that it's a logical flow of events through from what has delayed you to the ultimate time and compensation that you're looking to try and get out of the process.
Okay. Ian, do you want to add anything?
Only thing I would add to that is that obviously that things don't happen overnight. You know, you've got delays and such like and potential issues. You should be having these conversations regularly with your client or consultants or whatever around the table, so that it isn't coming as a shock. You don't suddenly get to week 34 of a 35-week contract and saying I want a 10-week extension of time. It's all about timing, and if you communicate early and effectively point out where the impacts and such like can be, sometimes it makes it easier to get to the award of an extension of time without having to go through a process of formal adjudication and such like. But at the end of the day, what Gus and yourself have said is you need to be able to demonstrate that, and that's down to the information you've got at your fingertips, including all your records, etc. But you should be having that conversation early.
Yeah, absolutely. I totally agree with that. This is where early engagement is so critical, and I think we need a grown-up approach of sitting around the table and the contractor saying, look, we've got a potential delay coming up here for the following reasons, and we think if we do X, Y, and Z, we may be able to circumvent the problem. That's the sort of discussion that we need to have instead of warfare by email and letters, etc., etc. And Gus quite rightly mentioned a previous webinar about notices. Now, this is one of the things that I see an awful lot where people don't comply with the notice provisions. Rudy Klein gave an example. If it says you have to give somebody a notice and they're sitting on the top of Mount Everest, then that's what you've got to do. It's just been it's a silly analogy, but you've got to comply with the notice provisions in the contract. And that is absolutely fundamental. So, Ian, is that us?
That's us. No more questions, Lem.
Okay. Well, we'll call it a day, folks. We've got 32 people on the call. Thank you very much for your interest. I want to say a big vote of thanks to our presenters, Ian, Gus, Deborah Harrison, and Rudy Klein. They've been absolutely brilliant, put a huge amount of work into this. And also the comms team, the presentations are absolutely fantastic. So, hope you've had a lot out of these seminars. Stay safe, stay out of trouble, and hopefully we'll see you all in 2021. Many thanks. Thanks for joining us.
Thank you.